This is Freeman 317. Today is August 30th, 2012. I know a lot of you who are subscribed to me has been wondering what's been going on because I've been missing in action basically. And there's a lot of BS been going on. And really didn't know where to start. I mean, there's so much I need to go over, but due to the fact that I'm having a problem with my internet service provider, as well as my computer has been hacked. As far as my service provider, my account is paid in full. It's overpaid actually, and they disconnected my services, and it will not turn my internet back on unless I give them a month in advance. Now, how can you do that when my account is current and you shut my services down and you owe me money back? Okay, we'll get into that in another video when I have time to upload it, because like I said, I don't have internet, so I'm going to start doing the videos, and I'll load them up when I can until I get this straightened out. But the last thing that happened was about the last time you heard from me. And what happened was Mark Osborne, buddy of mine, was kidnapped by a government agency and taken from Indianapolis, Indiana to Grayson County, Kentucky. And what they claimed was that they didn't have enough room, since it was a federal case about the ID that Mark had. They claimed that since it's a federal case, they didn't have enough room for him here, so they transported him to Kentucky, Grayson County, Kentucky. Now, this was the arrest sheet because he just disappeared, and he was arrested it's saying the 18th. He was arrested on the 17th, which was Monday morning. He was booked into Kentucky, Grayson County, Kentucky. He was booked in there on the 18th, September 18th. He was arrested September 17th. Well, they held him in Kentucky until Friday. So they held him from Monday. Well, they held him here in Indianapolis on the 17th. So from Tuesday the 18th, September 18th, to Friday, September 21st, he was held in Kentucky. Now, being that he was representing himself, they set it for a competency hearing on that Friday the 21st, the day that he was released. But the thing of it is they trumped up charges on him. They threatened him, coerced him, and kidnapped him in order to get him to do what I'm getting ready to tell you they got him to do. Now, let me show you what got him. Let me show you what got him, what got up under their skin. Let's just say that. This is what he found, and he also recorded it at the county recorder. Now, this is a notice of rescission of signatures. Excuse me. In common law, I, Mark Anthony, domiciled in the state of Indiana on this 17th day of August 2012, except for invocation of power of attorney granted to Tyree Jamel Moore Jamel of the family Moore as attorney in fact for Mark A. Osborne, the all cap name, knowingly hereby extinguish, rescind, revoke, cancel, abrogate, annul, nullify, discharge, and make void ab initio all signatures belonging to me on all previously signed orders setting condition of release and all powers of attorneys real and implied connected thereto to the cause number, then his case number, on the grounds that my purported consent was not voluntary and freely obtained, but was made through mistake, duress, fraud, coercion, undue influence, exercised by officers of the United States of America in the state of Indiana. This was recorded at the county recorder, so here's the certified copy. I was induced by fraud, coercion, and duress to sign such forms, and I was denied full disclosure of the voluntary nature of such forms. I was misled by those who knew or should have known into believing that filing and or signing such forms was mandatory and or implied, were unconscionable and grossly unfair to me. I was unduly influenced and coerced. I put in coercion, but it was supposed to be coerced, but they know what it is. By the stronger bargaining power of officers of the Court of the United States of America and or the state of Indiana, and acted under an implied threat and fear of potential imprisonment for non-compliance. Any alleged consent and or signature of Mark Anthony Osborne on any adhesion contract through the court or any political subdivision thereof is null and void, as it was given under duress, by mistake, by coercion, and by fraud, notwithstanding any information which you may have to the contrary. Any forms that have been filed in this cause and any implied quasi-contracts that the United States of America and or the state of Indiana for this cause may feel it may have with me were filed illegally and unlawfully under color of law and without force and effect. Attached as Exhibit A is the order setting conditions of release and is hereby hereinafter and forever canceled and null and void. I further revoke, rescind, and make void ab initio all powers of attorney pertaining to me from officers for the state of Indiana and or the United States of America, and for any and all government quasi-colorable agencies and or departments created under the authority of Article 1, Section 8, Clause 17, and or Article 4, Section 3, Clause 2 of the Constitution of the United States, not to include power of attorney given and declared to Tyra Jamel of the family Moore as attorney. In fact, I hereby affirm that the foregoing, oh boy, it's early in the morning, you guys. I hereby affirm that the foregoing is true and certain and not misleading, so help me God. And he signed it. All rights reserved. It's been notarized. This is the attached exhibit. What was it? Exhibit A, I think. This was the attached exhibit. Exhibit A, which is 3 pages, which is the order setting conditions on release. Now this is in regards to an ID that someone else made about over a year ago. Mark purchased it. The federal government arrested the guy who actually made the ID. Now Mark and everybody else who received that ID is a victim, and now they're being treated as the criminal when they know Mark did not make this ID. This is the fraud that's going on. They're trying to claim he made this ID, and they know for a fact who made the ID because they arrested him. Okay, I know the guy personally who did it as well. Okay, they came and got him, took his computer, everything, arrested him, let him write out or whatever, but they know who made the ID and they know it was not Mark, and they are fabricating these charges against him, which they filed a false claim into the court of public record. Now there are about 20 of us that's getting ready to do lawsuits against the United States of America and the state of Indiana in the district court, okay, for this, because this, as well as other things that they are doing to us. So, and the proof is there, because through a Freedom of Information's request pertaining to the guy who actually made the ID, we can obtain the records to prove that somebody's already been charged with this exact crime, alleged crime, because he was responsible for it, and now they coming after Mark, basically saying the same thing, and he had nothing to do with it. But for those of you naysayers, I'm not even going to argue with you about that. We have the facts, okay? So let me get on to this. Or this is now, excuse me. So let me get on to this. Or this is now, excuse me. So let me get on to this. Or this is now, excuse me. My point about these conditions on the release is, for one, it pertains to an ID, and for two, it Mark was not the one who made it, and for three, this makes no sense for somebody charged with as petty of a crime that actually is not even a federal offense for him to have to go through this. Now, before I continue, I'll tell you that here shortly, but here's the order setting conditions on release. This is what they made Mark sign to. It is ordered that the defendant's release is subject to these conditions, and everywhere he initialed is what he had to do. The defendant must not violate state, federal, state, or local law while on release. The defendant must cooperate in the collection of DNA samples if it is authorized by 42 U.S.C. subsection 14,135A. Now, here's the problem. Why is he having to submit to a DNA sample? They're treating him like he was a murderer or a child molester or a rapist or something of that nature. Okay? And this is about a BS ID, okay? But anyway, the defendant must advise the court or the pretrial service office or supervising officer in writing before making any changes to his residence or telephone number. The defendant must appear in court as required, and if convicted, must surrender and as directed to serve a sentence that the court may impose. Then this was his next court date, but they hadn't set it yet, so it had nothing on it. Let's see, we're just gonna he must submit to supervision by and report for supervision to the pretrial agency. And then the telephone number, they don't have a telephone number, and then it says no later than as they instruct, which is bullshit. Continue to start an education program. Well, continue or actively seek employment. Now, Mark makes about $25 an hour, been on this job for over 20 years. So, he has the job. Continue or start an education program. Surrender any passport to U.S. probation office. Not obtain a passport or other international travel documents. And right here they let you know that there are other international travel documents besides a passport. You guys need to think about that. Abide by the following restrictions on personal association, residence, or travel. He's restricted to the Southern District of Indiana unless pre-approved by pretrial agency. Then avoid all contact directly or indirectly with any person who is or may be a victim or witness in the investigation or prosecution, including any co-defendant or potential co-defendant if related. Do not discuss case. Defendant is not to have contact with anyone involved in the Indiana Republic. Now, how can you tell them it can't be involved with somebody? But it gets deeper than that when I get to tell you what happened in court. Not possess any firearms, destructive devices, or other weapons. Now, they have violated his Second Amendment right to bear arms and defend himself, being that they're telling him he cannot have a firearm in his house. Now, he has a gun permit and his wife has a gun permit, even though they're not needed. Not use alcohol, and then it says excessively. Now, Mark does not drink, so that wouldn't have been an issue. Not use or unlawfully possess a narcotic or drug. He doesn't do drugs. Submit to testing for a prohibited substance if required by the pretrial service office or supervising officer. Testing may be used with random frequency and may include urine tests, the wearing of a sweat patch, a remote alcohol testing system, and or any form of prohibited substance screening or testing. The defendant must not obstruct, attempt to obstruct, or tamper with the efficiency and accuracy of the prohibited substance screening or testing. Participate in one of the following location restriction programs and comply with its requirements as directed. It is marked home detention. You are restricted to your residence at all times except for employment, education, religious services, medical, substance abuse, or mental health treatment, attorney's visits, court appearance, court-ordered obligations, and other activities approved in advance by the pretrial service office or supervising office, or. And then it gives some others, but this is the one that he signed, had to agree to. Submit to location monitoring as directed by pretrial service office or supervising officer and comply with all of the program requirements and instructions provided. Report as soon as possible to the pretrial service office or supervising officer every contact with the law enforcement personnel, including arrests, questioning, and traffic stops. And then defendant is subject to random searches of his person, residence, and property by U.S. probation officer and pretrial services office and or any law enforcement officers accompanying them. I mean, in which is ridiculous. Over an ID to the defendant, you are advised of the following penalties and sanctions. And it says an offense punishable by imprisonment for a term of 5 years, but not less than 15. You will be fined not more than $250,000 or in prison for not more than 5 years or both. Now, over a damn ID, rapists don't even get this much, child molesters don't even get this much, pedophiles don't even get this treatment or this much BS. You see what I'm saying? It's ridiculous. They're doing this because they know their ass is in trouble and they're trying to stop him. Let's see. The defendant is ordered released after processing. Now, this is after he was originally so-called indicted. Okay. Now, so I told you this is what got him arrested, right? So you probably wondering, well, why did this get him arrested? Well, first of all, he canceled the contract. He canceled the pre-release agreement, and he voided the indictment. How did he do that? Let's go see. Let's scroll down. How did it say? I know you barely can see it. This is a copy. It says order. This is his order. He say, it is hereby, hereinafter, and forever. It is hereinafter. Let me see. It is hereby, hereinafter, and forever declared that this order, setting conditions of release, is void, is null and void, in accordance with United States Supreme Court case Madison versus Marbury, 5 U.S. 2 crunch 137, 180, 1803. For those of you who know about Marbury versus Madison, you know how powerful that case is. Then it says the signature and initials of Mark Osborne on this agreement is hereby canceled, rescinded, and null and void from this day forward and hereinafter, and then he signed it. So basically, he voided the indictment and the charges because it is null and void per Madison versus Marbury as well as others. Now, it was stamped on. It was stamped on the order setting conditions of release, each page. And we didn't do the indictment, but the order setting conditions on release. He fired the attorney and canceled the pre-release agreement. Is what happened. So what he did was took that down to the attorney over a month ago. It's probably been a month and a couple of weeks now. Now, they actually held it for a whole month before they even said anything. The attorney called him, I want to say, he was arrested on the 17th. That attorney called him about 3 or 4 days prior to that. So about the 14th, 15th, the attorney called him and told him that this document is not, what he said, this document is not proper. It is not the way we do things. He didn't say it's against the law, it's not valid, none of that. He said this is not the way we do things. And you have a court hearing scheduled for the 21st, and I want to know if you're going to be there, or do you need me to continue? Now, first of all, he fired you, so why would you be calling him, telling him, trying to get him to accept another, continue the case or whatever? And then he said, oh, and you have a warrant out for your arrest. And then he paused. I heard the voicemail, and he paused and he said, I believe. Now, first of all, if Mark actually had a warrant out for his arrest, he would have a warrant out for his arrest, and the attorney would know. The attorney is in contact with the court at all times. So if Mark had a warrant for his arrest, in reality, he would have said, and also you have a warrant out for your arrest and you need to turn yourself in or do this and do that. He kept trying to get him to allow him to continue the case. He was basically trying to get Mark to rehire him. So Mark didn't respond to it. And that's when the day before some other things were getting ready to be filed in the court, they arrested him. Now, they have our phones tapped, so I'm for sure they knew what was getting ready to happen. And I'm not going to even talk about it. So, Monday, September 17th came. I believe it was 10 o'clock in the morning. They kicked in his door and arrested him. Now, he's supposed to have a warrant for his arrest, right? For not complying, I guess, with the pre-release conditions. Now, here's what they did. They kicked in his door. They arrested him. They towed all his vehicles, every one. Now, the vehicles was not in the warrant, okay? I don't even know if there was even a valid warrant. I believe it was not. But they came and arrested him on an alleged warrant for failure to, comply with these conditions on release. But then you turn around and tow every one of his vehicles. See, here's what they were doing. They was trying to cause him a bunch of stress, a bunch of problems in order to trick him. So they had to do a lot of things. Now, here's what they done. They kicked in his door. They arrested him. They towed every single vehicle off his property. Mark had about 5-6 vehicles. They towed all of them. They had no authority to tow them. That's number one. They took him to Kentucky. We are in Indianapolis, Indiana. They claimed that there was no room for him here, and they took him to Kentucky and held him for 4 days. Now, why did they do that? I tow all your vehicles. I take you to Kentucky. You basically done missed 5 days of work already. Okay, so I done told your vehicles that's gonna cost you a lot. You know you got to get out to get them out because you the only one can get them out right now because they're in your name. I'm gonna take you to Kentucky, which is take you out your element, take you out your comfort zone, and make sure you're not able to really have contact with certain people. And then I'm gonna bring you to court the following Friday, which was September 21st. And when he came to court, you would think he was a murderer, shackled to the stomach, feet shackled together, chain around his stomach with his hands shackled to the chain. Quite a few of us was in court. Okay, they were not happy. First of all, they didn't allow me in the court because I didn't have ID, and they made me go home and get an ID. As soon as I left the building, they started the hearing. I was able to make it back. As soon as I walked in the door, it was probably 30 seconds past. The judge jumped up, went on out the courtroom, claiming that he could not decide on to release him or not, or decide anything because he doesn't know enough about the case. But that wasn't the issue. The issue was they were trying to get all of us out the courtroom. So while I was gone, I had people taking notes. All the other people that came were taking notes and listening and everything. And what happened is they told him that they made him give up his sovereignty. Okay, this is on record. We're doing a freedom of information request and getting all information pertaining to Mark's trial, Mark's hearing, Mark's charges, the court hearing, everything. Okay. They told him, they coerced him into giving up his sovereignty. They coerced him into basically going back to being a citizen of the state. Okay. They also coerced him into agreeing not, now they specifically said my name in this court. They said you are not to have any contact with Tyra Moore or his associates. I don't know where I get associates from. But they basically was talking about me and everybody that was in the court. Now, mind you, while Mark was in Kentucky, his wife was talking to the attorney. The attorney claims that I have Mark doing this and all this bullshit. Now, first of all, me and Mark met because we were both doing this and didn't know each other. That's how we met. So I don't have anybody doing this. Okay, that's number one. He was doing this before we met. Okay. Number two, the attorney told her, oh, he's crazy, he got all these videos on YouTube, and I think he's the one got Mark doing this and blah. They just badmouth me like I don't know what, because they are scared. He got all these videos on YouTube and he's crazy. Okay, whatever you say. Okay. Now, they specifically told him he cannot be around me or nobody I deal with. He cannot have any contact with me. Okay. They convinced him. They also made him. Now, if this document, if what we did was not valid, wouldn't all they have to do was dismiss it or throw it out? They didn't do that. They made Mark on the public record rescind this rescission. Okay? They made him cancel his document. They didn't do it. They made him. You are going to have to not have any contact with Tyra Ray's associates. You're going to have to agree to the pre-release conditions, and you're going to have to cancel and rescind your signature off of this. And he did. But it was under threats, duress, and coercion. Okay? Now, if this was not powerful, why would they make him, hold him, and make him cancel his name off this document if it's not powerful? Okay? And if it was not valid? You need to think about that. Now, so they got him to agree to all that shit first, right? And then that's when the judge says, well, when I walked in, that's when the judge was saying, well, I don't know enough about this case and I can't make a ruling, and I'm going to send it back down to the other judge that set these conditions. And he told the Mark's attorney and the prosecutor to get in contact with the other judge to see if she can hear the hearing this evening. Now, what it was they was trying to get us out of the building and from being able to hear the rest of the hearing. because soon as we left, a couple hours later, the same judge that claims that he didn't have enough knowledge of the case to make a ruling, the same judge called Mark back in after we all left, probably a couple hours later, and went on and accepted his rescission of this document, his agreement not to have any contact with me and everybody else, and the other agreement statement, giving up his sovereignty and all that. And they only did it because they didn't want us to be there. Okay, that's why they act like they was passing it to another judge, and then they brought him back when we left. And then they end up releasing him. Okay. Now Mark's been in the service. He's not a criminal. He only been arrested, I believe, one other time, which was in regards to this. Well, 2 times. One was for driving, which he beat the charges, and the other was for this. And so he's never been, he's never been held over 8 hours. Okay, so they had him for approximately 4 days. They had him out of his state. They took him out of the state. Okay, and they threatened and coerced him. Okay, so not being able to deal with it, having a job making $25 an hour that you have not been at work for about 5 days, and you cannot risk losing your job. Now let me back up a little bit, because what they told him also to get him to agree to this is the attorney told him that if he do not agree to all this and cancel his signature and agree not to be around me and give up his sovereignty, that they're going to set this for another hearing, and it could be a couple weeks, a month, maybe even 2 months before he even comes back to court. They was basically saying, we're not letting you out, and it's going to be another 2 weeks, maybe a month, maybe even 2 months before you come back to court. They knew he was going to lose his job. Then he has a 10-year-old son he's taken care of. They used that bullshit against him to convince him to agree. Okay, and the transcripts will prove what went down. Okay, and all the witnesses in court can do affidavits and criminal complaints against them because they heard what happened. Okay, so for them trying to change their records, that's even more fraud if they do. But he was released and basically haven't talked to him. And let's see, he was released on the 21st. This is the 30th. It's been on about 10 days. Okay. And he's not to have any contact with me or anybody else. Okay, which is bullshit. And they know what's coming down. And the problem, the reason I'm gonna tell y'all, the reason why they done that is because when they had that bench trial, when he had that bench trial on that one traffic issue that he did lose at a bench trial, which it was nothing. They realized that he was not prepared to defend himself, so they knew basically what they can do. And what I am telling you people is, if you don't understand, you may think you do, but if you don't understand what's really going on and understand how to properly protect your rights and defend yourself at all costs, and not allow these people to trick and coerce you and scare you into agreeing to something that you do not want to agree to, they are going to come for you. That's why it's mandatory that you learn the rules of the court, all the rules of the court, the trial rules, rules of evidence, rules of professional conduct, rules of judicial conduct, and know how to recuse the judge for bias and prejudice, disqualify a judge, and how to also stand and protect your rights. Okay, you have to know this. If you filing documents, is if you don't know how to defend yourself and you're not prepared to actually defend yourself and go up against them, and not take a court-appointed attorney, which makes you a juvenile, incompetent to handle your own matters and or affairs, but you're supposed to be sovereign and self-governing and able to handle your own matters and affairs, then they are going to get your ass. They are going to scare the shit out of you. Okay, so I suggest you learn what the hell is going on in these courts, and you know how to properly defend yourself for this happening to you. See, me, I'm not working. I don't have nothing to lose. What I got to lose is my life and my freedom. So I'm damned if I do, I'm damned if I don't. Okay, so you can't, for you agents that's watching, you won't be able to scare me. Don't even try it, okay? Because you're not going to trick me into no agreement. You're not going to trick me into hiring no attorney or taking no court-appointed attorney. None of that. I will defend myself in the court. And anybody involved in the deprivation of my rights and property will be sued and held criminally liable, okay? But for those of you who do not understand or know how to do this properly by yourself, you don't need to be doing this shit, okay? Because, listen, when they know you listen to somebody, when they feel that you're following somebody, they're going to use you as an example. When they know that you actually can't defend yourself without having help, they are going to come after you, okay? Just to get you to back down. Now, if he didn't have freedom and sovereignty, why did they in the court make him specifically give up his sovereignty? If things that I am doing is not tearing their ass up, why would they make it mandatory that he have no contact with me? I'm not a criminal. I haven't been convicted of anything. Okay? I'm for sure they're watching me. They've been following us. They followed us all the way from the court. And they're probably listening. Let them know we seen them 2 or more cars in the state trooper car specifically followed us all the way from the court. We went and had a group meeting, you know what I mean, after the hearing, just to go over what went down. And they followed us all the way. And if they think we didn't see them, they're crazy. Okay, we've been being followed. They have been creeping around my house. I mean, I basically, like I told you, I gives a shit. I feel that's one of the reasons my internet is shut down, because they probably been in contact with Bright House. But nonetheless, I'm working on that because I'm getting ready to sue Bright House. But I'm just letting you know why you haven't heard from me in a while, what has been going on since the last time you heard from me, and what actually didn't happen, and what they did to my guy Mark. Okay? Now, they can't tell him he can't hang around people. None of us are criminals, right? But y'all said he can't hang around us. He can't hang around me specifically. They say me and my associates. They had my name in the court record. He is not to have any contact with Tyra Moore. And, I mean, it's ridiculous, people. But I'm gonna tell you right now. Thinking you're just gonna file some damn paperwork and it's gonna be over? Nope. You better know how to defend what you file. If you don't know how to defend it, don't file it, okay? Because they're going to tear your ass up. And that's where you need to get together in groups regularly and do study and research on the court rules and procedures. You need to be going over Supreme Court rulings that protect certain rights that you are trying to defend, okay? You need to understand the rules of the game. You cannot go to a chess game with basketball with checker strategy. You're going to lose every time. All these people out here telling you they don't do code statutes and all that old BS. Well, you have to in order to get them in their own, beat them at their own game. You cannot go to, like I said, you can't go to a football game with basketball strategy. You can't play a chess game with checker strategy. You're going to lose every time. You have to come to the game with the rules of the game. Learn the rules of the damn court. Learn how to defend yourself. Learn what protections you have within those rules. Okay? And, I mean, this could go on for quite some time. But, I'm going to go ahead and end this, and I'll probably make another video so I can get somewhere and load them up. But this is the update of what went on. And you have any more questions, just leave your comments, and I'll keep you updated on what's you know, what we're going to be doing. You know, I'll just let you know what else I find out about Mark. But as of now, he's not to have any contact with me. So, Freeman317 signing out. Leave your comments.